Welcome to SCOTUScast, Public Employees, Agency Shops, and the First Amendment edition. Thank you for tuning in. On March 29, 2016, the Supreme Court decided Friedrichs v. California Teachers Association. A group of public school employees sued the California Teachers Association and various other entities, arguing that the agency shop arrangement itself, as well as the opt-out requirement, violated the First Amendment. The District Court denied their claim, and the U.S. Court of Appeals for the Ninth Circuit affirmed, based on existing precedent in the 1997 Supreme Court decision Abood v. Detroit Board of Education. The two questions before the Supreme Court were, 1. Whether the Abood precedent should be overruled and public sector agency shop arrangements invalidated under the First Amendment, and 2. Whether it violates the First Amendment to require that public employees affirmatively object to subsidizing nonchargeable speech by public sector unions, rather than requiring that employees affirmatively consent to subsidizing such speech. In a one-sentence per curiam opinion, the judgment of the Ninth Circuit was affirmed by an equally divided Supreme Court, a 4-4 split. To discuss the case, we have Richard A. Epstein, the Peter and Kirsten Bedford Senior Fellow at the Hoover Institution, Laurence A. Tisch Professor of Law, New York University School of Law, and Professor Emeritus and a Senior Lecturer at the University of Chicago Law School. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Professor Epstein.
Everybody who heard the oral argument was perfectly clear that the vote was 5-4. It is now a 4-4 deadlock, and so we do not get the opinion of the majority. We do not get the opinion of the dissent, because there are none of those things. We get a one-sentence line, and there's no reason for me to try to parse it for you. It's also clear in terms of news that the organization involved in this thing is basically going to decide that they're going to push this case forward for a rehearing. This would be Terry Pell, the president for the Center of Individual Rights, who issued a statement today about how the court was split on union fees and how it was that he would try to get this thing resolved, obviously in his favor, once it came out. There were some things in this statement which actually I did not quite know, and it was a good statement. He says, California teachers pay about $650 a year in agency stop, but given that they're agency players, they lose benefits like maternity leave, disability, and professional life insurance, which sort of indicates to you the following very simple point. If there are people who are prepared to opt out of the union, it's clear that when they do so opt out of the union, that they are paying serious costs for that, and so it would be a mistake, I think, to think of this simply as an economic decision. It's also a decision that many of the people who are teaching are not, in fact, people who believe that what the union says or what the union does is consistent with their own sets of responsibility as to how government relationships ought to be organized with respect to unions. And now, at this particular point, there's nothing you can do to analyze the opinion as such because there is none, but it's interesting to sort of go back and to reflect upon the pattern of argumentations here because it sort of shows the sort of opportunistic nature of the way in which people on both sides of the issue tend to think about many of the issues. So the first point that sort of comes up in this particular case is the extent to which the doctrine of stare decisis really ought to govern under these particular circumstances. The reason why it's so important is that there was a very thorough consideration of this entire issue in a case called Abood against the Detroit Department of Education, and I think it was 1977, in which Potter Stewart, who is very much a centrist judge, thinks that he could maintain the line which says that teachers in an agency shop situation could not be required to contribute to political causes that were run by the unions, but they could be required to contribute to those things which involved economic issues. And he thought that the line between these two groups was particularly stable. And back in 1977, when I think it's fair to say that unions were political, but much less politically active than they were today, you might be able to see some degree of daylight going between these two areas. What is also clear is as the world has started to move on, the efforts of unions to continue to push very hard for strong benefits is in fact more conspicuous now than it was 40 years ago. The sort of cutting edge issue on this particular point is, I think, without question, the issues of work rules on the one hand and on pension benefits with respect to the other. So you've got two very large issues here. It's quite clear that public pension systems, I think, are in a state of disarray today that they were not in 40 years ago. And it's also clear, particularly in any cities, that the sort sort of the crisis in the classroom and inside these schools was much more serious. There was at that particular time a very weak charter school movement, a very weak homeschooling movement. Now all of these movements have gotten much stronger, and union activities have necessarily shifted, in part at least, from the bargaining table to the legislative front, because they are under very intense pressures to try to cut down the funding for any competitor that they happen to face, i.e. the charter schools are a perfect example. The city unions work extremely hard and diligently in order to basically upset them in every conceivable kind of way, and so the political dimension of unionization today is, I think, much greater than it was 40 years ago. And so in the Supreme Court, at the time, the four liberal justices knew that they were on shaky grounds with Scalia sitting with them on trying to win on the merits, and so they spent a lot of time trying to talk about stare decisis as one of these guiding variables. It is, I think, the case that, shall we say, that stare decisis is one of these values to which people adhere with great passion when the precedents are on their side, and one that they look to with great resentment when it turns out that they run the opposite way. And so if you want to consider some of the great reversals that we've seen, it's kind of instructive to ask, how they came about and why. I mean, the most conspicuous of these, of course, is, I think, Brown v. Board of Education overruling Plessy and Ferguson, and that was, I think, a case of sort of general moral inevitability, where everybody finally saw by 1954 the evils of a system of segregation, which essentially at its peak was not regarded as that big an issue. 1896, when Plessy came down, all the way through the Woodrow Wilson administration, segregation was part of national life, but it wasn't the life and death issue because there wasn't much controversy about it. And then as the steam starts to move in the opposite direction, I think the justices were quite rightly to say that, we can't abide this kind of system, half slave and half free, as it were, and they overturned it. You get other kinds of decisions which are supposed to be radical differences, like Griswold in Connecticut, and there you start to say, well, virtually every state has decided to legalize contraception anyhow, so when you make it illegal to ban this in Griswold in Connecticut, what are you doing? Not very much. On the other hand, when you get to Roe v. Wade, where in fact you override a series of precedents which are in fact enforced in virtually every state, either through common law criminal situations or more often by statute, it's really a very big deal. And of course, it was the liberals who drove that. And most recently, the Obergefell situation with respect to same-sex marriages was, of course, another huge reversal with respect to precedents. Again, dealing with a situation in which there's some degree of fluidity in the state level, but there was no strong constitutional support for the constitutionalization of the same-sex marriages under the Equal Protection Clause, and the same liberals who are sort of touting the virtues of stare decisis in this particular case are the ones who are quite happy to override it in the other. I don't put much weight on these arguments on either side. In general, I do think that stare decisis is a fine doctrine, particularly when everybody happens to support it, but the only cases in which it gets challenged are those in which there are genuine, deep philosophical decisions at the current time, and there you would expect to see people split on the merits. So when you start to then look at the particular merits, what are you supposed to say? Well, if you're somebody like myself who's essentially intellectually unreconciled to the constitutional revolution of 1937, what you say is a lot of things, which is that we should never be in this particular place in this particular situation in the first place. To the extent that any of these union protections are done as a matter of federal law under the National Labor Relations Act, the two strong objections are the commerce power objection on the one hand and the sort of economic liberties objection on the other hand. I think both of these are perfectly valid. I'm still very much a believer in the late 19th, early 20th century synthesis on both of these points. Economic liberties preclude forced negotiations. The Commerce Clause does not extend to local activities, would be the way I put it. But of course, in dealing with many of these situations, what you do is you have state statutes which do the authorization so that the due process objections start to remain, but the Commerce Clause type objections disappear because of what's going on. If, in fact, you take this, I would also raise another objection, which I've talked about for a long time. I think basically every public office is a public trust. I think the job of public administrators is to maximize value for the state at large. They cannot do that if they shower monopoly favors through statutory authorizations upon unions or anybody else. A union, for my mind, is no different in this particular regard than any kind of industrial organization. Sweetheart contracts that give you wages above the competitive price and terms that no competitive market will sustain are, in this view, essentially out of kilter and should not be expected. So I would not even get to the First Amendment issues. I think the economic liberty issues and the government fiduciary duties issues are sufficient. What happens, of course, is today that you see people going in exactly the opposite direction. Economic liberties have been dumbed down to the point where they don't exist, but First Amendment liberties tend to be much stronger, and so what happens is the legal arguments migrate to where the standard of scrutiny that is given unto a particular decision turns out to be the highest. And in this particular situation, that means that you're starting to go to the First Amendment and saying that the political association issues really matter, and given everything that we've said, that it turns out that the line between the political and the non-political speech is not tenable. Forcing people to contribute to a union that does things that are antithetical to themselves is, I think, regarded as a mistake. Michael Carvin, when he made his argument, I thought had a very nice phrase in which to encapsulate that. The unions start talking about free riders, i.e. people who get all the benefits to which they contribute, none of the burdens, which is wrong given the fact that agency shop workers get fewer benefits. But Carvin, decided that no, the better way to talk about them is as compelled riders, as people who have been forced to join into a cause in which they don't believe, who would be only too happy to have their emancipation. Many of them don't like unions for economic reasons. They think that they're going to be able to better under themselves under a meritocratic system than they are being locked into a union system which raises the bottom and lowers the top and creates a kind of leveling effect which is antithetical to advancements of people with genuine teaching skills and intellectual excellence inside the public school system. And I think it's a pretty good argument. The solidarity argument, of course, has always been used on the other side with respect to free riders, and Justice Scalia, writing about this issue some years ago, actually mused aloud that he thought that the free rider argument was pretty strong, and so what happens is his words were used against him in most of the briefs. Now, in many ways, let me just say that I think the most interesting things that I saw were briefs by the Buckeye Foundation, Robert Alton, I think the Mackinac Foundation, in which they actually ask a very simple question. What happens when you start having right-to-work laws? What does it do with respect to unions? And, usually the story is that unions are going to find themselves massively deflated when these situations are put into place and that their ranks will be shattered. And certainly there are some cases in which that's true. There was a lot of difficulty for the members of the American Society dealing with state, municipal, and local and county workers in Wisconsin when Scott Walker basically undid the collective bargaining system there. But if you actually look around more comprehensively, it's a rather interesting and somewhat surprising story. And let me just briefly mention what the story is, because I think it's an encouragement. Well, the first thing we know is that since the Taft-Hartley Act, states that wanted to adopt right-to-work laws in the private sector were free to do so. And we see a consistent movement on the part of many states into that particular camp, none going in effect the other way. So that in recent years, we've seen Indiana, Michigan, and Wisconsin in the Midwest moving in that particular direction. And so then the question is, what happens to unionization? Well, in a place like Michigan, I think it actually goes up slightly. And the question is, what's the explanation for seeing this? And the way in which it's been put to me, and I'll repeat it now, strikes me as being rather appealing. The first thing to understand is, if, in fact, you don't have a right-to-work law, the union has a monopoly as against the potential members, and it could demand very favorable terms for itself. Once you give people the option to opt out, then all of a sudden the union has to compete with non-union organizations at this point, and what's going to happen is it's going to change the terms of trade. And sure enough, if you start to look at this, there are several effects that happen all at once. One is that the salaries to union officials start to go down now that they're facing competition. Second, the benefits that go to workers in the form of lower dues start to go up. And third, when you're an employer dealing with a union like this, knowing you're in an outright to work state, the negotiations that are going to take place are going to be rather different than in a circumstance where the union has a very dominant and controlled position. So at the end of the day, when you're going through all of this stuff, what happens is you have a slight rise in union membership, but the unions function in very different ways. And in fact, oddly enough, they are more competitive institutions than they are in other situations. Well, that seems to me to be a very powerful point explaining why it is that the usual rules of competition, in fact, what to be done. And it's interesting that the conflicts here are not only between employer and union, they're also between unions and non-unionship or non-union membership. And in this latter particular capacity, the ability to opt out of unions and essentially makes employers and employees, and unions, more sensitive to the needs of the particular employees who are empowered with these sorts of options. How will this thing come out when the thing has gone through? Well, everything is going to depend upon the fifth nominee. If it's a person like Merrick Garland, an able man and generally a well-respected judge, he's going to vote liberal on this issue, as he has on virtually every other labor issue that has come in front of it. If it turns out that by some miracle, if that's what it takes, the Republicans win the presidency, hold firm during the last months of the Obama administration, and control the Senate in 2017, you'll get a Scalia type. This case will surely come back, and the 5-4 result that everybody predicted before the untimely death of Justice Scalia will now turn out to be a reality.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.